Good morning, everyone. Welcome to this week's weekly live immigration attorney chat here at Immigration for Couples. And thank you all for staying here live. I've had a busy morning of immigration here, getting clients ready for interviews and phone calls with immigration. And so had a little bit of a busy start to the day, but I'm glad you were all able to stay here so I can go over your questions. And welcome. I see we have a lot of individuals who are regulars who are joining us again. So welcome back. And if you are new to these live events, Immigration for Couples, my firm is dedicated exclusively to helping couples across the nation and across the world in navigating the U.S. immigration process. And my team and I, we know how important it is for you to all have clarity and guidance throughout this process. And so that's why we have these weekly lives. So you know you have a community where you can get up-to-date information about what is happening in the world of couple-based immigration. And we also have a free resource center. Ria will put that in the comments as well, and you'll see it below. It's at immigrationforcouples.com. All right. So a lot of you know the drill. Betty, I see you got it. So anyone who is joining us here live, please let us know, where are you at in the world and where are you at in your immigration journey? You can say beginning, middle, or end. And if you're watching us on the replay, please do the same. Just do a hashtag replay. Let me know where you're at in the world and where you're at in your immigration case. And more importantly, how are you doing? How are you all doing? So good morning, Lisa. Great to have you with us. Betty, I'm going to go back here to your comment. And I did see Phil and Ann are here. That's awesome. Good morning. You're waiting to be documentarily qualified and then for your interview to be scheduled. Yes, hopefully that will be happening soon. So that is great. Great to have you here. Betty, good morning to you as well. You're in Canada. Ginger, I saw you in here too. All right. So we can go ahead and dive into the questions that we have here today. So I am streaming this live on Facebook, LinkedIn. I believe should be on LinkedIn, YouTube, and Instagram. And so I will answer the questions in the order that I receive them. If you want to throw those in the comments here. All right, let's see who is first. So let's see. I'm going to give me a second here to read it because there's a lot of abbreviations. Yeah, I'm not, that's a lot of abbreviations here. So I think you're saying good morning, and if you're granted a 212 waiver with your adjustment of status for a crime involving moral turpitude, basis for deportability or inadmissibility, can DHS initiate removal solely based on the CIMT, which is a crime involving moral turpitude. So if I'm understanding your question correctly, you're wanting to know if you have a ground of inadmissibility, if you're applying for a waiver, is it possible that you could be placed in deportation or removal proceedings because of that ground of inadmissibility? And the answer is yes, it is possible. I can't say exactly, that will happen in your particular case. If that is your situation, you 100% need to have an immigration attorney assisting you, because right now, individuals who are applying for adjustment of status, so that's a process that happens here in the United States, you have to go to an interview in front of an immigration officer. And something that has happened historically and is happening even more given the current political climate is that if you have a ground of inadmissibility, if you have prior issues with deportation proceedings, if you have certain aggravating factors in your immigration history, when you go to that interview, they could place you in removal proceedings. So CBP ICE can actually, ICE, not CBP, ICE can actually be there and detain you and place you in deportation and removal proceedings. So yes, it's possible. And without, knowing the specifics of your case, I can't say, best strategy or the likelihood of that happening. So definitely you want to have an immigration attorney. All right. So Terry, A couple weeks ago, you had let me know that your husband had, yes, I remember that he had his second interview in Morocco and his first interview about 3 weeks before that, and they kept his passport. Then they called him in for the second one. They took all of the evidence, which was well over 200 pages, probably more, and it's been since a month since the second interview, and you haven't heard anything. Yes, that's definitely possible. Sometimes it can take months, even after you've turned in all of your documents and your passport, for them to make a final decision. The best thing you can do is reach out to the embassy. I assume you probably have. And so yes, that is possible for it to take some time, but good luck. Best of luck to you. We're all rooting for you, sending you prayers and positive vibes for a positive outcome for your case. So good luck. All right. I have some questions coming in here from Facebook too. And Elisa, you were saying the kids haven't called our office yet. Well, we're here whenever they're ready. So, Pete, oh, sorry, Pete, I'm gonna grab your question here just a second. You're very welcome, Terry. Hopefully one of these lives you come back with some positive news about the interview. So, Pete, do they provide interpreters when you go for your marriage interview? So there's two kinds of interviews. There's an adjustment of status interview that happens inside of the U.S. at a USCIS office in the state where you are living. At those interviews, it is your responsibility to bring an interpreter. If it is a consular interview, so that's an interview that happens for spouse visa cases abroad at a U.S. embassy or consulate abroad, those interviews, it will depend on the particular consular post. Typically, they offer more than one language. So for example, for our clients who are having an interview in Ciudad Juarez in Mexico, they would be able to choose if they wanted to do the interview in Spanish or English, for example. But for the adjustment of status interviews that happen in the US, it is your responsibility to bring your own interpreter. All right. And Maria, it's great to have you with us. Why records not found in response to a FOIA request? Okay, so the petitioner had records over 30 years ago at USCIS. Yes, it is possible that when you order your immigration file, because that's something that you can do in case, for those of you who aren't aware, you can actually order your immigration records from USCIS, CBP, OBIM. There's different immigration departments depending on the history of your immigration case as to where you would order those records. Sometimes they will say that they don't have records, even though you know that there was an application filed in the past. Sometimes it is because they're too old, but immigration does keep records for many, many, many years. They actually have records going over 100 years back in some situations. So you would just have to do the request again and provide even more details. Sometimes that can be a spelling of a name or not enough details for them to find the information. So any additional details you can provide, and then doing the request again would be helpful. But it is possible sometimes they come back and say there aren't records when you know that there are. All right. So Olga, you're wanting to know if it's safe to apply for adjustment of status with charges. So yeah, and I know you listed out all the charges here in the comments. Whether or not it's safe to apply is going to require a legal analysis of those charges, because some charges will have, the charges can be state specific. And then as an immigration attorney, I need to look not just the immigration law, but the state law at the time that the incident occurred to determine what is the maximum possible penalty and what was the actual penalty, to determine whether or not is it a crime involving moral turpitude, for example? Is there a petty offense exception? I have to do a legal analysis. So no immigration attorney will be able to just have you tell them those charges like that and tell you whether or not you're safe to apply without doing a very extensive legal analysis. And so you're asking the right questions. You're doing a good job of asking the right questions before you just start filing things, because there are definitely crimes that can make you inadmissible. Some of those, and so inadmissible means not eligible to receive a green card. Some of those crimes, there'll be a waiver of forgiveness. some crimes and some incidences in your immigration history don't have a way to get forgiveness. They have what's called a permanent bar, which means you're not eligible. So it's very important you talk with an immigration attorney, and not just talk with them, but hire them to do research, review all of your records, and determine the viability and the safety of you being able to file for your case. So, and I know you listed out all the charges here. I won't pull those all up, but you definitely have some that are going to be in a more complex territory for sure. So, Julia, great to have you with us. And your file reached the Manila Embassy for the K-1 visa. Congratulations. That's exciting. You're making some good progress. And then you are wanting to know about the financial support piece of the case and what documentation. So the documentation that's required for the affidavit of support, or what I call at this phase, the affidavit of support, because it's the I-134 instead of the I-864, is typically you're going to have to provide 3 years of tax returns. And then it's going to depend from there. Is the petitioner self-employed? Do they have their own business? Are they a W-2 earner? Are they retired? Are you using assets? But for most individuals who are a petitioner and they are working and employed as a W-2 employee, then typically 3 years of taxes with the W-2s, or something called a tax transcript. You need paycheck stubs, proof of employment, like a letter of employment. Typically, that is the documentation that would be needed. Some consular posts prefer tax transcripts over tax returns, but definitely looking at the National Visa Center financial evidence or financial piece under the National Visa Center, prepare for interview. But in general, that's what you're looking for financial documents. But definitely double check based on your particular case. So I hope that was helpful. Robert, good morning to you. You're in Sacramento, California. Great to have you with us. Just going to go down here and see. Okay. All right, good. I just wanted to make sure that that answered your question. Looks like it did. And so Robert, your fiance, you will both get married on June 11th. Congratulations. That's very exciting. Just right around the corner. But she has to go to the Philippines on the 16th without an AOS. I plan on immediately filing both an I-129 and I-130. Okay, so the I-130 is the petition for the spouse visa process. The I-129, and I believe you mean I-129F actually, is for the fiance visa case. And so if you're legally married, then the process is the spouse visa, or the I-130. Yes, there's something called a K3 that allows you to file the I-129F. And I've had a lot of questions about the K3 over the past couple live events. And so I'm guessing that's probably what you're asking about. But yes, it's possible to file for the K3 using the I-129F after the I-130 is filed and you have a receipt. But as I talked about in the other lives, filing for the K3, which is what you're wanting to do, it's really a very archaic tool that's really no longer, they're not being approved anymore, because basically you're filing to be in 2 lines, and whichever line is faster is the case that would get approved and adjudicated and completed first, which is typically that I-130 spouse visa, because the wait times for K3s are longer. I'm not sure if that's the direction that you were trying to go with that, but you can't file them at the same time. And then also just understanding that the I-130 is for the spouse visa. So hopefully that helps answer your question. All right. After 4 years, your interview in Rio on July 9th. Oh, that's so great. Congratulations. Keep us posted on how it goes. I'm glad the videos have been helpful to you. Bill and Ann, great. Oh, yes, and I pulled your comment up. I'm just so excited to see you here. I just keep pulling your your comment up. All right. So your question is, can people who have a green card leave and enter the country without any problems? I heard that the president had signed a law that those with green cards could no longer leave the country, only after we focus on American I don't know if you mean American citizens. So I know that there's a lot of fear. That's what I'll say. A lot of fear around traveling with a green card right now. And that makes complete sense because the current administration is definitely testing the limits of what's lawful and really pushing the envelope on a lot of those limits of the law and trying to go beyond. And the starting point is that as a green card holder, you are legally eligible to travel outside of the country. There have always been, and there continue to be, certain risks for certain categories of individuals who have green cards. Individuals who have taken trips in the past over 6 months, or if you plan on taking a trip over 6 months, that's extremely risky and you shouldn't do it. Why? Because as a green card holder, while you're allowed to travel internationally, the United States has to be your home and you have to live at least half of the time in the United States. So trips out more than 6 months outside of the US can result in immigration determining that you've abandoned your residency. So long trips, that's a huge risk. Another category is individuals who have certain criminal history or certain immigration violations, prior removal proceedings or current removal proceedings in immigration court. That is extremely risky to travel on your green card, and you could get, stuck outside of the country in some situations. So there are definitely categories where travel is more risky. And it really is going to come down to the specifics of your case, but there is no rule or law that says the green card holders can't travel. And it's important to understand that while there's so much on social media and so much fear mongering, and I know there's a flurry always of executive orders and changes that are being announced, the president cannot change laws or make laws. The Immigration and Nationality Act, those are the written immigration laws. Those would take an act, an agreement of Congress to change the actual immigration laws. Do we have policies that can be shifted by the current administration or by really any administration? Yes. But the starting point is that green card holders are legally eligible to travel and there are risks for certain categories. So, and I'm going to actually be, my team and I are actually going to be releasing a video on this particular topic of green card travel. And I go into even more details. And I do already have a couple of videos on YouTube about it as well, where I talk about travel and risks with green cards right now. So I hope that helps answer your question. I know there's a lot of people who are worried about travel. You're very welcome, Robert. I'm glad that was helpful. Okay, good. Okay, so I'm glad that was helpful, Robert. Let me see who was next. I don't want to. Okay, Hector, you are from Georgia. Does immigration look at available funds from your bank as part of the decision making? In some cases, they can. So it depends. So who was it that was asking about the I-134? Julia. So Julia was asking about the I-134. So part of the green card process and the fiance visa process is the financial affidavit of support piece, where you as a U.S. citizen or lawful permanent resident petitioner have to show you make enough money to support your fiance or spouse. And for those who don't make enough or who are not currently employed, you have to use, or you typically can use, assets. And so assets is money that's in your bank account. And they look at how much is in your bank account on a rolling 12-month period, or over the past 12 months, what is the average? And in those cases, yes, how much is in your bank account can actually determine whether or not you will be able to qualify to receive a green card. But in general, the amount that is in your bank account would really only be relevant for that affidavit of support. And actually, for relationship evidence, that's another piece. I have videos coming out about that as well, but I'll talk about it here today, is that for your relationship evidence, if you have joint financial accounts, bank accounts, credit cards, things like that, immigration is going to look at how much is in there and how much activity, because they don't want to just see an account that has $100 in it and never has any money added or taken out. So they want to see activity, but it's not really about the amount. So I hope that helps answer your question. All right, who is next? All right. So your fiance, his interview, he was given the 221G and received a letter stating our case was returned to USCIS. Is this an eventual denial? He is from India. Okay. I'm really sorry to hear that. I know that's extremely stressful. I know you've probably waited a long time to get to this point in your immigration journey, and to have them send that back is definitely unnerving. So what can happen, especially in a fiance visa case, is that the petition, so that I-129F application you filed, when it gets approved, it has a validity of 4 months. So you'll see on there the 4-month period that it's valid. And then you go to your interview and you ask the consulate to extend those 4 months as part of the process. You ask for that extension. Unfortunately, in fiance visa cases, if the embassy or consulate has any doubts about whether or not your relationship is real, they can send the case back to USCIS. And typically what happens with fiance visa cases is that then when they're sent back to USCIS, that sending the case back takes a long time. And oftentimes they will just deny the case because that 4 months has expired. That's typically what we see. Is there a chance that they could do something called a notice of intent to deny and give you an opportunity to respond? It's possible, but unfortunately in the fiance visa context, typically that does typically end with a denial. So I hate to be the bearer of bad news. Hopefully, maybe there's a chance that that won't happen, but typically that's what we're going to see in a fiance visa case. So it's really important for any of you who are going through the fiance visa process, even once your I-129F is approved, when you go to your interview, that's a really, really extremely important day. Why? Because that immigration officer is actually the one that gets the final say about whether or not they think your relationship is real. And if they have any doubts, if they think that your questions are contradictory, if your answers to the questions are contradicting the evidence, if you don't bring enough relationship evidence, if there's any issues with your filing, if that consular officer decides they don't want to approve the visa and they send it back, unfortunately that can end in a denial. And so if you have a current immigration attorney, please speak with him or her about exactly what happened at the interview and how you can prepare for next steps in the process. If you don't have an immigration attorney, I'm happy to meet with you in private. All right. And we can talk in more detail. All right. I'm going to do a couple more questions and then I do need to jet. We had a lot here. Okay. And I know someone else has a question about the 221G and why they could have gotten it. It really is going to depend. It could be because of questions and responses that were provided. It could be because of evidence. It could be other issues in your immigration history. I mean, there's a lot of reasons why a 221G white slip can be given. They should have given you additional information or documentation at your interview. In administrative processing, it really depends. For some, it can be a few weeks. For others, if you need a waiver, it could be years. So hopefully they will be able to give you a decision soon. If you have an immigration attorney, definitely speak with them about what happened at the interview and any documents you were given to identify why you might have received this 221G, and definitely reach out to the consular post, to the embassy, and see if you can get more information as well. All right. Yep. Oh, but okay. Yeah, you just answered. I answered that question already. Okay. So Betty, yes, we have lots of clients from Canada. And how long were their wait times? It really just depends if you're talking about a fiance or a spouse visa case. For our spouse visa cases, it's important to understand that there are 3 different government entities that are part of the overall wait time. So the very first step, the petition for spouse visas, that's taking about 15 months. And then from there, the National Visa Center phase takes a month or so. And then from there, you're waiting on an interview, which takes like another 4 to 6 months for our clients in Canada. So you can kind of get an idea. I always tell clients to be prepared for about, right now, about a 24-month wait for the spouse visa. For our fiance visa cases from Canada, typically you're looking at about a 12-month wait, give or take. So about half the time. These are just estimates as of May 27th of 2025. They definitely are fluid and fluctuate, but hopefully that helps you give you a little bit of an idea. I wasn't sure what kind of case you have, so I gave you both. Excuse me. And Jose, you have a question. When you went to the interview. Wait, I don't know if I understand. Was there another part of your question? Let me see. Oh, there you go. I missed the best part of your response, of your comment. So, hello, great news. You were finally approved. That's awesome. Congratulations. I know you have been waiting a long time. You've been coming almost weekly and letting us know you've been waiting. And so congratulations. That's very exciting. And you're wanting to know what happens next. So you have to complete the National Visa Center process to be put in line for an interview. And from there, you will be scheduled for an interview. And then you're wanting to know about the card itself, if it'll be a 2 or 10-year green card. So at the time that your case is approved is when they will determine whether or not you'll receive that 2 or 10-year card. So for those who've been married for less than 2 years at the time of case approval, they will receive a 2-year conditional card. And those who've been married for more than 2 years will receive a 10-year card. Okay. So it'll really just depend on when that interview happens. All right. And there's some others who've asked questions, and I've answered a question. So I'm trying to answer or respond to individuals who I haven't been able to answer any questions from. So great to have you with us, Mitchell. If you apply for an I-130 and then a K3, will they overlook the K3 since an I-130 is filed? It says the K3 should be a quicker, but apparently it takes around the same processing time. The K3 takes longer. I know it seems like that's what it says online, but you have to file the I-130 first. And then I always consider it or think of it to be like a horse race. You have 2 horses, one in the spouse visa camp, one in the K3 camp, and then it's a race to see which one gets to the front first. And it's always the I-130. The K3 is really a very old, archaic tool that's no longer used. We filed it for clients who want to file those. But I had said in a prior live a few weeks ago, it's also important to understand if the K3 is approved, that it completely changes the process and it might not align with your goals. So the K3 is treated in large part like a fiance visa, where the individual is going to enter, and there can be some limitations in terms of having to be like stuck in the U.S. and things like that. It's a very long spiel that I don't want to get into all of that. I know I just want to answer the main question that you have is, will they overlook the K3? So yes, what happens is the I-130, the spouse visa, if that's the faster horse, which it always is, at least as of recently, as of many years now, then they will just adjudicate and complete the I-130, and then they'll close out the K3. So, I mean, yes. So, I mean, it doesn't necessarily hurt as long as you understand what the K3 looks like and what the next steps will be. And if that still is in alignment, for your goals and plans, but that's really what would happen. Oh, okay. So Betty, I answered your question then. You're doing a fiance visa. Okay. And then Pete, you were wanting to know about if it can be family members or do they have to have certain credentials? I highly recommend getting someone from an actual interpreting company and making sure they have experience with interpreting legal terms. Could you have a friend or family member? Yes, it's possible. You definitely want to ensure that they are fully bilingual in both languages, and that the reason that I'm recommending an interpreter, you don't have to have a certified interpreter, but having someone who has actually done interpreting and understands the officer will speak, and then the interpreter has to say exactly what the officer said, and then the immigrant beneficiary will respond, and then they have to say exactly, what the immigrant beneficiary says. I've had situations where friends or family members try to be the interpreter, and it actually doesn't work out so well. So can it? Yes, but ideally you want someone who is actually done interpreting in a more official capacity. So, and also to be a neutral party. So yes. And USCIS, if you look up in interpreter requirements, you can see more on their website about that. All right, everyone, I do need to jet. It was great to see all of you today. I know there's still a lot more questions coming in. It seems like we have a lot of questions about 221Gs. So I'll go through the questions that are here today that I haven't been able to get to. And a lot of times that's where I make videos from those questions, because if you have the question, likely others do too. It was great being with all of you. Please do check out that free resource center if you're just starting out or if you're in the middle of your immigration journey. I will be here again next week at Tuesday at 11 a.m. Eastern time. And so I look forward to seeing all of you next week. All right, take care. Bye.